Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video, we're going to briefly discuss the overall processing time involved in a U.S. marriage visa case, specifically the K-3, the CR-1, and the IR-1 visas. These are marriage visas for those who are married. Specifically, we're going to do this from the perspective of those who are married to a Thai national. The first thing to keep in mind is it's been my experience that you're looking at overall processing time for a marriage visa, CR-1 or IR-1, which are the actual classic marriage visas that utilize the classic methodology of obtaining a U.S. visa. The CR-1 and IR-1, you're looking at about 11, somewhere between about, in my experience, about 11 to 13 months between initial filing and final decision regarding approval. That being stated, there's also the K-3, and the K-3 is a supplemental visa application that is filed subsequent to the initial filing for a CR-1/IR-1 case. With the K-3, it's faster processing in the sense that essentially it can utilize a different channel for adjudication at the Department of Homeland Security, but as documented in other videos on this channel, the K-3's effectiveness is increasingly being sort of phased out, most notably because the reason for its creation, which was due to the fact that there were significantly lengthened processing times for I-130s at one time, the K-3 was created to expedite those marriage visa cases to those for those who were married to an American citizen as opposed to married to a lawful permanent resident. So it created a preferential category. That being said, I mean, a K-3, when all is said and done, I mean, you might save yourself a couple of months, but if you can manage to get it through, and it isn't administratively closed by the National Visa Center, there's further information on all of this, specifically in our video regarding K-3s on this channel. But back to the overall processing times, yeah, you're looking at about 11, 13 months, somewhere in there. It's gonna greatly depend on, just basically the circumstances at Department of Homeland Security. Is there a request for evidence issued? If so, that could cause delays in the matter. Then upon petition approval, there could be delays such as 221Gs at the U.S. Embassy here in Bangkok, where further documentation is requested in a given case. I mean, there's a myriad of ways of how these cases can be delayed or how they can move faster. Most notably with respect to, strictly speaking, CR-1 and IR-1 cases, filings for such visas for those who live in Thailand, American citizens living in Thailand wishing to bring their Thai spouse back to the United States, they can affect a local filing here in Thailand, and basically it's a much faster processing time because the local office here just doesn't have the same caseload as that which exists in the United States. And you could be looking at 4 or 5 months overall for one of those cases. That being stated, there are ways in which those can be delayed, notably things like establishing one's domicile back in the United States. These kinds of issues, they can be very paramount in a case for a U.S. visa. But keeping in mind, all of these notions, just bear in mind that, again, these are benefits being sought. They're not a right. They're not an entitlement. And they're being sought through an adjudication process that's primarily based on a doctrine in which really consular officers abroad have pretty broad discretion. You can check out a video on what's called consular non-reviewability, consular absolutism. The consular officers have pretty broad discretion with respect to approval and denial of U.S. visas. So bear this in mind that as long, or as fast or as slow as the process may be taking, oftentimes there's not a whole lot that can be done to speed things up. Sometimes there are things that can be done to speed things up, but oftentimes it's not a matter of anybody, it's not a matter of anybody not doing their job or not working with alacrity. It's more just a matter of, look, there's a massive amount of caseload involved with the U.S. government on these cases. They process them through as fast and efficiently as they can, but there's only so many hours in the day in this world, and there's only so many resources that can be dedicated to adjudicating these matters. So, it's not an overnight process. It takes time, but in routine cases, you're going to be looking at, like I said, 11 to 13 months-ish. Local filing here in Thailand is about 4 to 5 months, again, ish, give or take a little bit. The other thing to keep in mind is, yes, there's requests for evidence that can be made, which can delay things. There are 221G refusals pending further documentation provided that can delay things. And finally, something else to think about: if a legal ground of inadmissibility exists in a given case, and that's found to exist by an adjudicating consular officer, then the overall processing time of ultimately getting the visa can be radically changed, just by dint of the fact that it could take another 11 to 13 months to go ahead and get an I-601 waiver or an I-212 approved by the Department of Homeland Security. So again, this can radically alter the time frame. So again, the overall processing time is going to be determined most notably by the specific facts in a given case, and understand that not all cases are the same and processing times are going to vary. That being said, in routine matters, it's generally been my experience that U.S. marriage visas, the CR-1, IR-1, set aside the K-3, it's sort of a different thing, but in just routine, classic U.S. marriage visa immigration cases, you're looking at about 11 to 13 months. It could be faster, but that's been my experience, that's pretty well the routine processing time.